I will try to make a point that the legal environment has added value for the digital environment to make it much more enjoyable than as we know it today. So I will start with this tailored globe from one of our researchers of last year. And when we had this picture, so while you're still trying to find some flags you know, and maybe the flags which are not there, this is a picture of attempts of national governments to regulate digital environment on the basis of what they know about that, on the basis of problems identified, be it political ads, be it personal data protection, be it fake news, be it disinformation. So these are individual national efforts to legislate digital environment. So seeing this picture, we asked ourselves, haven't we come to the point in history when we need to approach digital environment as a whole and look at the possibilities to regulate it as a whole domain? So fast forward, the reply is yes. We came up with a list of items which are typical for the whole domain and which would facilitate the digital domain based on rule of law, based on transparency, based on reasonable oversight. And I will talk about that a bit later. So the next question we had before we started this project was, would it be possible to very successfully and easily and quickly adopt existing legal regulations in the physical domain for the digital domain? So, for example, the media laws and regulations, how adjustable would they be for the social media? Because as you know, the social media is a phenomenon which legally doesn't have any definition, which is not related to media in any sense. So fast forward again, the reply would be no. Unfortunately, there is no such fast solutions. There could be elements from the media regulation. There could be elements also from other domains, like financial domains, which could be elaborated and adapted and used for regulating digital domain as a whole. But these are solutions and options to be discussed and elaborated. Another question we had, the third question we had was, okay, so we would like to explore these two things. Whom do we need to have in a room? Who would be the experts who would provide us the knowledge and their views valued for the discussion? And we ended up, fast forward, we ended up with a room full of different experts. We definitely had a digital business, social media, Latvian national social media in the room. We had legislators from different countries. We had legal scholars. We had media experts in the room. And why it's necessary is because we need to recognize that if we want to have approach to the digital domain, not specific digital businesses, which we know today, but we don't know what will be there tomorrow. So we need to have all stakeholders in the room in order to have this result trustworthy and transparent. Another aspect is that it definitely needs to be international and multinational process. And I'm saying that, for example, on the basis of EU case. So if you look at the European Union and the digital, so the states of European Union have shared competence with regards to internal security and freedom and rights. A lot of problems identified by national governments with regards to digital environment are problems which influence internal security and freedoms. So having states being solely responsible for freedoms, at the same time, those freedoms and securities are affected by digital domain, which is crossing all physical borders, and acting and being used in EU countries on the basis of EU single market rules. So it's not possible for the states only solemnly to regulate and take care of their national security issues. So there is a role, with this example I want to say that there is a role already of international organizations in assisting national governments and maybe even in some cases leading forward discussions about the digital domain. Legal regulations for the digital domain. So having these multiple experts in the room and having the questions I mentioned, at the end we found out that there are a lot of ideas, a lot of issues raised which could be necessary to regulate. And which would facilitate the rule of law in the digital domain. So we divided them in theoretical two parts. One is part which is legislating the issues, which is very much visualized in this slide. So those are basically the issues we know today. And as I say, those are patches we are applying on the problems we know today. But if we look at the digital, it develops very fast, and it will develop for some time, and we don't know the problems of tomorrow. The other stream of issues identified were the issues which would be common and need to be addressed for the digital domain as a whole. So I will talk about those a little bit later. So from the issues we know and approaches national governments have attempted to take with regards to regulating existing environment, so you can have approaches, four kind of approaches. So the regulating content, regulating processes, regulating business models, or via regulating artificial intelligence. Actually, artificial intelligence should be a block by itself. But since we were discussing digital environments, so I also included that because the same principles would still be applicable to artificial intelligence regulation. So I will touch on some of these points here mentioned in this slide. To begin with regulating the content, this is something what is most widely used by national governments. It seems easy, kind of reasonable, kind of something what we know. No, actually, but it's quite opposite what we decided at the end of our discussions. It looks quite a bumpy road, and in some cases, unfortunately, it might even lead to dead end. So why? Because if we see from the not national but international perspective, and we need to remember that digital actors are cross-border functions and businesses. So, for example, the illegal content. So, illegal content is set by national legislation. What is illegal in a country? For example, there is a recent case which was brought to my attention about the whistleblowers. Whistleblower case in US. You know that there are certain developments currently in US politics based on the whistleblowers report, and by the law, it's not allowed to make this name public. So, but there was a tweet with the name of this person. It is illegal content, but not outside US. Or not in the countries which do not have regulations with regards to whistleblowers. So there is illegal content according to national legislation, which is not the case if you look from other countries' perspective. So how can countries will at some point come to the common definitions of what is illegal and in any case, a lot of things in these discussions will depend on the small cultural and historical backgrounds. The same about the freedom of speech. We kind of know that it's written in the UN Constitution. Everybody relies on freedom of speech. Nevertheless, if you zoom in, you will see that within national legislations, it's very much varies where are the borders of freedom of speech. For example, in the US, the freedom of speech contains burning a flag, which is not the case in several EU countries. In Latvia, for example, it is forbidden to use former USSR flag out in public, which is not the case in other EU countries. So if you zoom in, you will see there are so many differences which among the countries, and So the content regulation in this regard would require the countries to come to common sense what are the limits of freedom of speech within EU at least, or what is the legal content within EU. But it will be problematic, because I'm aware about the discussions at the EU which were attempting to reach a ban on alcoholic beverages in the EU, or to regulate advertising of alcoholic beverages in the EU, and I was told that the EU countries didn't agree what is alcoholic beverage. So, with this in mind, that's what I mean when I say that it's quite bumpy and it might end as a dead-end road. So, the transparency. The transparency was raised today several times, and it's actually, when we look closer, I think we need to recognize that there could be three kinds of transparencies we are talking about. So transparency towards the users, what we all expect, transparency for the research, and transparency for the oversight and for control of making sure the transparency is actually full picture what we see. So in this regard, transparency is very important, and it should be looked at, and we need to also recognize that by doing that, we will also have to engage in a discussion about who will oversee implementation of this transparency. And then we go back to the discussion on overseeing institutions of digital world. Should there be one? I think if we wanna have some rules which are binding for digital actors, there should be somebody who will oversee how these rules are being implemented. And here, actually, we draw a little bit perspective, parallel with the banking and financial sector. And we were looking at the banks. The banks are highly confidential and very discreet toward the users and so on. Nevertheless, there are independent national and international institutions who are overseeing the banking business. And actually, today, I think we cannot even imagine our life without it, taking into account all the money launderings and financing of terrorism going on. So it is doable, it is possible, and I think it is necessary. So regulating business models, it's the same. We came out to conclusion that it's also a bit, there are similarities with the banking world. And it is, so there are the banks whose business is considered to be more trustless or more dangerous for the national security, for the business community as a whole, or for its users. What I mean here there are certain understanding in the financial world that banks who are more inclined to work with non-residential accounts are more dangerous for the national security of a country or for banking system of a country than banks who work with residential accounts. And what we have separate and different requirements, more strong requirements, more strict requirements towards these banks. We have different overseeing of these banks. Why I'm saying that is because we discovered that also digital business and income of digital business can be of different models. For example, the social media, Latvian social media, which participated in our discussion, so they let us know that for them, 70% of income comes from users, not from ads, but from users. And they are, by definition, do not accept political ads already since, a long time ago. So where their income comes from is from very, very symbolic and small amount of money they are charging the users for their curiosity. So if you want to know who looked at your account, who watched your pictures, so you need to pay, you will have this access. So what I'm saying here is that by this example, that there are different business models possible also for the digital business. And the threats the businessmen are choosing this their business models could influence how they are regulated and overseen. regulating artificial intelligence, I will just say very shortly that the understanding is that this should be comprehensive legal regulation based on human and fundamental rights. Why human and fundamental rights? It's because there are already certain frameworks in place to interpret these norms and to enforce these norms. So there is already certain footprint available which could be used. That also will spare us from long discussions among democratic and authoritarian states about what are the rights, what people can expect, what they cannot expect. Nevertheless, yes, there are such a phenomena or approach as ethical technologies. And some digital business also tend to apply, and they claim that their technologies they use following ethical principles. That all is good, that all is fair, all is fine. This could be a path to be followed. But on another hand, it doesn't have these already existing infrastructure for interpretation and for enforcement. But that could be worked out. Why it should be? Yeah, I think I will just. Okay, so about the approach of digital domain as a whole. So what are the things we recognized which are common for the whole digital domain and which could be implemented and developed? So as I mentioned before, multi-stakeholder approach and multilateral agreements. That is something what we found, which there is no way on that digital environment could be developed on the basis of national legislations. Human rights and fundamental rights, enforcement networks, this is what I talked, and that would apply to all digital businesses. It doesn't need necessarily to be artificial intelligence. It also goes with social media, commercial business, commercial digital business, and as I said, with these approaches, we keep in mind that we do not know yet what will follow. Standard legal definitions for technologies, that is something that doesn't exist. As I mentioned, there is no legal definition for social media. And also the same applies for other new technologies, digital technologies. In legal terms, if you want to have somebody to be responsible and liable for something, you need to define who this somebody is and what he or she is responsible for. So, and that all ends up with the legal definitions. So and the same also goes for human rights. So we have human rights conventions, and we have human rights councils saying that the same rights offline apply also online. But in order to understand and implement this very generous regulation, you need to adapt these norms to the digital environment. We need to remember that UN Human Rights Convention was written in 1950s. There was no digital. There was not even internet at the time, very widely known. So all these norms, should be applicable. That's totally fair. But there should be done interpretation how these norms will work and how these rights should work in the digital domain. And this brings me back to multi-stakeholder approach. Another important point is about the government competence in the digital environment. So what was brought to our attention by the digital business was that there are not much understanding in the government about what is digital business, what it entails and how it works. Very often it's even mixed with cyber, meaning cybersecurity. And there are countries who are actually looking for solutions for that. For example, in the US, as well as in the UK, there are one-stop approach. So there is one agency who provides advice to all government agencies, including legislators and enforcement agencies, including courts, about what is necessary for them to know in order to fulfill their functions. So that is one agency in the government which provides expertise, knowledge, and whatever assistance is necessary for the government institutions with regards to, in their cases, internet crimes. In this case, it would be digital. And that would be reasonable, because I think if you want to have a digital expert in numerous state agencies, that will be very, very expensive. So this definitely would be more cost effective, and it should be there already. If we want to approach the legal regulation of digital domain, or even of any single digital business, be it social media, the legislators and enforcement, meaning police and prosecutors and the courts, they need to have some knowledge. And the last but not least, the national overseeing institutions, this is what I also mentioned before, their role and something what would also need to have to be elaborated. So these were a couple of points we discussed and we came up. There is a printed version of executive summary of this research, but there is whole research on our website of the center, and you can find these and also other points with regards to legal regulations. Thank you.